Hi, this is Juliana Gaeta, and as promised, I am going live on my page to discuss some of the changes that are going on and are effective today under the Florida Dependency Statute, which is Chapter 39. So I'm going to give everybody a little bit of time to begin joining, and when this is done, I will attempt to also just post it on the page so everybody can kind of just watch it at their convenience. A little bit about me. I'm an attorney. I am licensed in the state of Florida and the state of Massachusetts. I practice all over the state of Florida. My office is in Boca Raton. So a lot of times the majority of cases that we are handling are in Broward or in Palm Beach, but I do get retained all over the state of Florida to assist in these types of cases. I'm recently board certified in adoption law, but a lot of my real knowledge of this, while I am knowledgeable in the law, a lot of this knowledge that I have has really come from my time as a foster parent. I was a foster parent for, I guess, 6 years, probably around 6 years. I've had over 15 children come in through my home, in and out. We've adopted, my husband and I have adopted 3 children through foster care. So my passion comes from that. My having gone into this area of law is because of that, and I am always looking to update and help foster parents navigate this process because I have lived it myself and I know the challenges and the joys that really come with it. So I'm going to kind of get started. The 2021 legislative session passed 2 bills this session that I think are going to have a significant impact on Florida's child welfare system. And some of those changes to that statute go into effect today. So they were presented and signed by the governor, I think June 28th maybe, don't quote me, but they are effective today. So as of today, if you are Googling the statute and pulling up the statute, you are going to see this new language in there. I think this legislation is very focused on improving and utilizing good social work skills, and really in regards to children, they're looking more at attachment, at stability. I think there is a recognition that children, I always say, are not light bulbs. They can't be unplugged and then replugged in and then expected to shine just as brightly, okay? So, and I've heard the analogy of potted plants, and I think the science shows us that, the social work shows us that, and I think the law is catching up to that. And that's what this is an attempt. So with all of that being said, there is what I think is really exciting legislation is going to come out in 39522, and that is really what is going to affect foster parents. But before I get to that, I'm going to talk about some of the other changes that I think are probably less pertinent to foster parents and caregivers, but are equally as important for children. So 39, there's a section being added. It's an entirely new section. It's going to be 39, Chapter 39. When I talk about 39, that's the Florida statute. So it's 39.01375. I believe so. Sometimes I get the numbers confused, but I think that's it. And it's going to talk about what you have to look at, what the court has to look at each time it makes a placement for a child. When you're looking at what is the best place for a child. And you're going to look at each child's individual needs. And that's what I'm seeing in the statute and some of those changes as well, is that, yes, it's great for siblings to be together, but sometimes it's not. And so we're going to not just make this blanket decision of siblings need to always be together. We're going to look at each child individually and determine what is best for that child. And that's kind of that theme I was talking about of good social work coming in. So there are factors, I think there are 15 factors that are to be considered when every single time that you're looking at placement for the child. And that's going to be the age of the child, the physical, mental, and emotional health benefits, the stability and longevity of the current placement, the reasonable preference of the child, the established bonded relationship with the current or proposed caregivers, the recommendations of the guardian ad litem, the current relationship with siblings, if it will separate or reunite siblings. And I like to point out that under Chapter 39, and a lot of people know this already, but under Chapter 39, siblings is a little bit more broader defined than what we would maybe colloquially think of as siblings. But siblings are defined as any, legal or natural siblings of the child, but also any children that the child has lived with that they consider to be their siblings. So that can include foster siblings as well. We're going to also, one of the factors is the likelihood of attaining permanency in that placement, the likelihood of school change. We don't want to constantly move children in schools because the science shows that they get set back academically every time they're forced to pick back up in another school. You're going to look at the allegations that cause the child to enter care, the impact on the activities that the child is engaged in and that are important to the child, and the impact to education, Medicaid, and independent living benefits. So if a child is being moved out of state, that might affect some of their benefits, and we're going to look at that to determine whether or not this change of placement is in the best interest of the child. And then the last kind of catch-all factor is any other relevant factors. And now another thing that has been added to the statute is priority of placement. And we haven't had this before, but we're talking about what are the best placements for a child to go to. And so I don't have it listed out here, and I won't, but a foster family is pretty low on the list. Like, we're going to look for the other parent if they're non-offending. That's going to be priority number 1. Then it's going to be, I believe, relatives. Then we're going to look at what's called fictive kin. So somebody like your best friend who your children call auntie, that's going to be a preference. If they're willing to step up, we're going to prioritize that in terms of preference for placement. Then we're looking at somebody who doesn't have a relationship with the child but's willing to step up. So maybe somebody you go to church with, or someone that goes to church with a child and has heard about the situation and wants to step up, or the librarian at the school. Those placements are going to be given priority of placement. So that hasn't been in the statute before, but we're going to kind of look at that. And then if these placements, and this is predisposition, this is when the child first comes into care. So we're going to be looking at those for priority of placement. So the next part that I think is also kind of going to affect children and caregivers more is that when we're talking about a change of placement, what we're going to have to now do is whenever there's a physical change in placement of the child, there is going to have to be a multidisciplinary team that meets. So kind of like a staffing. And they're going to have to be held, and there are mandatory participants to that meeting. So the mandatory participants of that meeting that have to discuss this change of placement are the child, the child's family, the current caregiver, so that would mean foster parents, the DCF rep, the CBC lead agency, and the child's case manager. So the staffing can't be delayed because those people are not able to attend, because obviously time is of the essence whenever we're talking about dependency matters. But after reasonable notice of that meeting, those people are required and expected to attend. And then there are people that can also attend but are not required. So like the guardian ad litem, the child attorney, those are the different people that, other professionals, maybe teachers that can be invited to attend but aren't mandatory. So I think that's kind of a big deal, because a lot of times I hear from clients that change of placement decisions are kind of being made without involving the current caregiver, and that's an issue. And I think it's fine. It's being recognized as an issue. So if that team that kind of meets, that MDT team meets, and they have a unanimous consensus about the decision-making of where this child should be placed, then that is going to be kind of the official decision of the lead agency, and it's binding on DCF to take that position. If they don't reach unanimous consensus, then the facilitator of that meeting is going to notify the court, and then DCF kind of addresses how to identify the goals of that staffing and what position they're going to take. So I think that's really neat. That's getting a lot of people that care for the children, that know the children involved in some of this decision-making process. There's another section that's going to be added that's completely new, so it's not revising any section, it's totally new, and that's going to be 39.4023. And that is going to be talking about transitions for children, because what we've learned and what the science shows is that you can't just, and this has been ongoing for years, you can't have a child go to school and then after school come home and say, oh, guess what, you live here now. That is devastating for children. That causes trauma. It seems to be very common sense to know that, but now it's going to be codified in statute. And so this would be in a non-emergency situation, but there needs to kind of be a notice requirement and a transition plan for the child. The transitions can't take place between 7 a.m. and 7 p.m. and 8 a.m. So no like overnights, again, absent emergency. This is going to be Statute Chapter 409 already kind of references this transition plan, but now it's also being put into Chapter 39, so it's kind of cross-referenced. What that will do, I think, will just ease change of placements for children, allow them to be able to get their stuff. We know it's important for them to say goodbye to the people that they've been living with, all of those things. Their friends that if they're moving, a far location, friends that they've had. So those are all, I think, really exciting things, and you guys can look at the statute and look at 409 as well and see what is going to be required. And those transition plans are supposed to also be in writing and told to the child if they're, if it's age appropriate. So the most, I think, exciting changes that are coming are to Chapter 39.522. So 39.522 recently underwent a change not too long ago, maybe a year ago? I don't remember, but pretty recently. But now it's kind of being overhauled again. And this is talking about contested changes to physical custody of the child. And legal custody. So in the past, I've seen situations or scenarios where if a child is in foster care, they're already considered in out-of-home placement. And DCF was able to, a lot of times, if everyone agreed, or even without agreement, I guess, could move that child from one foster home to another without really needing anyone's approval. And that was because you're not changing the legal custody of the child. The child is still in out-of-home care. You're just changing the physical custody of the child. But now this statute specifically talks about, we're talking about the change in legal custody of the child and physical custody of the child. There is an exemption when we're talking about interventions or private adoption, because that is a process by which you are changing the legal custody of a child, but this statute exempts that. So we're going to kind of put that aside. That's a whole different animal and ball game. But what this is going to do is, if this child is not reunifying, this doesn't talk about reunification. This is changing placement from one placement to another, legal or physical, but not reunifying with a parent. If the child has been in the home of the current caregiver for 9 months, consecutively 9 months, and that current caregiver wishes to become a permanent guardian or adoptive parent to that child, and they're willing to become that as a permanent placement, and they're not the ones requesting the placement or change, then if they don't agree with that change of placement, this is really interesting. So you will be able to request a court hearing, an evidentiary hearing about that. So basically this is now saying caregivers who have been pretty much long-term caregivers, 9 months consecutively, have the right to say, I don't agree with this change of placement and I want an evidentiary hearing before the court. Putting on an evidentiary hearing with a bunch of attorneys there by yourself is going to probably be difficult. So most people will consider at that point hiring counsel. But there are certain provisions of what you have to do. So if you object to the change as a caregiver, you have to notify the court so it says so both people, and the department of your objection and your intent to request that evidentiary hearing. in writing within 5 days after receiving notice of the department's official position provided under paragraph 1 of that statute. Within 7 days of receiving notice from you, the court has to set a kind of like a status hearing, okay? And they have to then, for the limited purposes of this hearing, grant you party status. So I don't know if you've been involved in this or you've heard this. You're a participant, not a party. And what does that really mean? You know, I talk about that all the time with my clients and on some of these videos. Participant versus party is kind of up for grabs. It means something different in every courtroom. Some courtrooms, it means you can file motions and argue, but you can't do discovery. Some courtrooms, it means you have to sit there, and if you're called upon, you can answer a question. So it's very different, but now this unequivocally, for this purpose only, makes you a party to that action. So you are now able to conduct discovery, present evidence, put motions before the court. What it does, which is also strange and will be interesting to see, it says, however, once the judge enters an order, you are no longer a party once the judge makes written findings. Therefore, I think what that means, and it's kind of a strange thing, so we'll see how it plays out, is that you cannot appeal the judge's order or decision, which is unusual in our American court systems, that you would not be able to then appeal an adverse ruling of a judge because it bumps you down to no longer having party status, and the courts have already found that you have to be a party in order to appeal a decision. So I think it's kind of, it's getting there. It doesn't give you like full party status because you really can't appeal. So that's I think it's a little watered down. It seems like if the judge is making an oral ruling and not a written ruling, that you might have to have your like finger on the button to upload a notice of appeal. I don't know. It'll be interesting to see how that plays out, but certainly these are a lot more rights than we have seen for caregivers in the past. Anything more rights for children, because I think that's part of it. It's not just giving more rights to caregivers, but it's to the caregivers who are the ones who know those children day in and day out and who have been with them, you know, for 9 consecutive months of placement. So once you get to that status hearing, the court is going to then appoint an attorney for the child. So if your child had not previously had an attorney, which throughout the state, so we're a little bit maybe spoiled in Palm Beach County and even in Broward County, a lot of the children in care have attorneys, but there is no right to an attorney. That was something that was not passed during this legislative session. But most throughout the state, children, even though they are parties to the action, don't have an attorney, which exactly is going to kind of what happens in 39.522. You become a party, you don't get appointed an attorney, you either have to hire an attorney or you have to figure out the rules of evidence and put on your evidentiary hearing. But so the court will appoint an attorney for the child. They will advise the caregivers who are objecting of their right to retain counsel. They will appoint, this is interesting, they'll appoint a neutral expert, that's what it says, neutral expert, who will provide their findings to the court. So either a psychiatrist, psychologist, a bonding assessor, I really don't know who that's going to be, but will then kind of make a report, almost like how the guardian does, but it's going to be somebody who's neutral in this setting. Which you probably, if you're putting on an evidentiary hearing, you're going to want to hire your own expert to be able to also put on findings and make put on their findings to the court. So it might end up becoming a battle of the experts depending on what the neutral expert says. And the court then has to issue its order and findings within 90 days. So that this is kind of an accelerated process. Although 90 days is still 3 months from the date of the hearing. I think it's 90 days from the date that the hearing goes on, or I'm not sure if it's 90 days from, I can't remember now, if it's 90 days from the date that you've first requested the hearing. But obviously we don't want to delay. If there's to be a change of placement, the court's not looking to delay and the legislature's not looking to delay. We're trying to make these things happen as expeditiously as possible in, you know, dependency terms. So then if the court does change the placement and makes findings to change the placement, there is going to have to be that transition plan that we talked about with that statute. So it's not just going to be, okay, change of placement, and this is, and we find, you know, the court would have to make a finding for some reason that it's in the best interest to just move the child immediately. And that is probably not going to happen because, well, I want to say not going to happen. We never know what's going to happen in dependency, but they are going to then have to follow that part of the statute that now codifies what the transition plan to look like. So they're still, you know, going to have to look at factors. So previously, point 39.522 listed out different factors that the court has to look at when determining what's in the best, when a change of placement is in the best interest of the child. But now the caregivers essentially have the right to put on evidence to show and speak to all the different factors as they are outlined in Chapter 39. So it's kind of really big news, guys. I think this is like a really positive. I think all the changes that are coming, and that's not all the changes. This is all part of Senate Bill 80 that went through. So you can kind of take a look, and maybe what I'll do is I'll kind of post the old statute, at least 39.0522, and the new language, and you can really see the overhaul that went on in that section. I think that this is like I'm excited about it. I think it's a really good move in the right direction to recognize that children, you know, like we said, aren't potted plants, and to kind of give a voice now to caregivers who are really playing these important roles in children's lives, and who want to, you know, assist in reunification, of course, but also if there is a scenario where we want to try to limit the amount of times children are moving before reunification. So reunification is obviously always the goal. That still remains the goal of Chapter 39. But now, after 9 months, if the child is not being reunified, and we're just talking about any type of change of placement, the caregiver is going to be an important part of that discussion. So if you have any specific questions about any of your cases that are going on, you guys are always welcome to contact me. If there's, you know, I would suggest everybody contacting an attorney at any point if there's going to be a change of placement that you think you might not agree with and you've had that child for a while. I think it would be good to kind of go over the statute again and what that might look like in the court for you, and for your child and your family. So thank you guys for joining in. I'm going to post this. If you have any other questions afterwards, you can throw them in the comments and I will try to answer them if I can through Facebook. If not, like I said, you're welcome to contact me, and I look forward to hearing from you guys. I look forward to seeing all your pictures of your beautiful kiddos that you are caring for, and thank you, of course, for all the hard work that you are doing day in and day out for these children. Take care.